Welcome to the Kemp IT Law Vlog. I'm Richard Kemp, and this is one of a short series in which we look at what happens where law firm regulation and legal tech intersect. These vlogs are based on pieces we've contributed with Paul Longhurst, director of Three Kites, the UK's leading specialist tech consultancy to law firms, for the Navigating Legal Tech column in Global Legal Post, whose URL is on your screen now. Today's theme is how should firms approach data retention and what are the key legal aspects they should bear in mind. Back in the day, firms held onto their documents and timesheets for as long as their paper or IT storage systems would allow. With the introduction of GDPR, attitudes have changed, but many storage habits haven't quite caught up yet. 4 legal areas will shape a firm's approach to data retention. First, who owns the file? The Law Society provided helpful guidance on this last year. The general law makes a distinction between documents prepared where the firm is acting as client's agent, original documents sent to the firm and final agreements, for example, which the client owns, and documents that the firm owns, like copy letters and emails, meeting notes, draft agreements, and time and accounting information. Second, the firm and its solicitors will be subject to the SRA's codes of conduct, which cover confidentiality and disclosure. Tensions can arise in practice between the SRA rules and how assertive the firm wants to be around data ownership, disclosure and retention. Will the firm want a lien over documents for unpaid fees, for example? How will it handle disclosure requests in the context of a potential client claim? Third, it's really the GDPR that has focused a lot of attention on data retention recently. Here, the 2 key points are subject access requests, SARs, and the GDPR's storage limitation principle, that personal data should be kept for no longer than is necessary for the purposes for which that data is processed. This has led to the firms developing more elaborate retention policies over the last few years. All these points, file ownership, SRA and GDPR duties, come together in firms' client engagement terms and privacy policies. Most firms don't currently expressly set out in their privacy policy what the data retention periods are, preferring to give an email address where the firm can be contacted for the specific applicable period. But where a particular period is expressly referred to, this is typically 7 years after the final bill. Law firms have traditionally been magpie-minded about information. These developing rules will increasingly deter firms from retaining anything that glitters and encourage a more disciplined and structured approach. If you'd like to find out more about our work with law firms, check out our website at kempitlaw.com.